Hello and welcome to A Seat at the Sitting for April. I'm Nate Kazmarek, Vice President and Director of the Practice Groups. This morning, we look forward to a great preview of the upcoming oral arguments before the Supreme Court. We'll do our best to squeeze in as much analysis and discussion as we can in the next 90 minutes or less. And we'll also save time at the end to take questions from our audience. As you know by now, the Federal Society doesn't take any positions, and all views expressed today belong to our speakers. I'm delighted to welcome Elle Rogers as our moderator this morning. Elle, how are you?
Nate, I'm great. How are you doing?
Very well, thank you. Thank you for joining us. As I was mentioning before we started, I was going to ask you how things are going on Capitol Hill, but based on my commute this morning, I take it that things are relatively quiet for the Easter break. Is that so?
Yes, we are in 2 weeks of recess right now, so things have kind of mercifully calmed down quite a bit.
Well, very good. And again, glad that you were willing to carve out some time to be with us this morning and help guide the conversation. Elle is a general counsel for United States Senator Jim Banks of Indiana. She previously clerked for Judge James Ho on the United States Court of Appeals for the Fifth Circuit. Her law degree is from the University of Chicago, and her undergrad degree in philosophy is from the King's College. Full bios for Elle and our entire panel are available for your review on our website. The panel today will cover the upcoming cases, and then we'll go to audience Q&A. So please start thinking about the difficult questions you would like to shoot their way. For those watching on Zoom, your questions can be submitted with the Q&A function at the bottom of the screen. And with that, the table is set. Elle, thanks again. The floor is yours.
Thanks so much, Nate. Like Nate said, I'm Elle Rogers. I'm so excited to be joining the Federalist Society today for this month's Seat at the Sitting. We'll be covering the Supreme Court's April docket, and there is a lot to cover. I'm so grateful to be joined by 6 incredible, very learned panelists. The format of today's event is that I will introduce our panelists. I'll turn things over to our panelists to introduce our cases, and then I will go over just a couple cases, and then we will turn things over to the audience for some Q&A. Because we have so many cases to cover today, there might be a little bit less time today than there might normally be for Q&A, but we're going to have a great event. I'll begin by introducing our panelists. First, we have Thomas Berry, who will be covering Kennedy versus Braidwood Management and Diamond Alternative Energy versus EPA. Thomas Berry is the director of the Cato Institute's Robert A. Levy Center for Constitutional Studies and editor-in-chief of the Cato Supreme Court Review. Before joining Cato, Thomas was an attorney at the Pacific Legal Foundation and clerked for Judge E. Grady Jolly of the United States Court of Appeals for the Fifth Circuit. He holds a JD from Stanford Law School and a BA from St. John's College, Santa Fe. Second, we have Brian Fitzpatrick, who will be covering Parrish versus United States and LabCorp versus Davis. Brian Fitzpatrick is the Milton R. Underwood Chair in Free Enterprise and a professor of law at Vanderbilt University Law School. Professor Fitzpatrick joined Vanderbilt's law faculty after serving as the John M. Olin Fellow at New York University School of Law. Before entering academia, Professor Fitzpatrick practiced commercial and appellate litigation for several years at Sidley Austin in Washington, D.C., and served as special counsel for Supreme Court nominations to U.S. Senator John Cornyn. He graduated first in his class from Harvard Law School and went on to clerk for Judge Diarmuid O'Scanlan of the United States Court of Appeals for the Ninth Circuit and Justice Antonin Scalia on the United States Supreme Court. Third, we have Francesca Ugolini, who will be covering Commissioner of Internal Revenue versus Zuck. Francesca Ugolini spent 22 years in the Appellate section of the Department of Justice's Tax Division, where she directed all of the federal government's civil tax litigation in the Courts of Appeals and assisted the Solicitor General's office with tax cases in the Supreme Court. Ms. Ugolini received her JD from the University of Virginia School of Law and her BS from the University of Maryland at College Park. Fourth, we have Sarah Parshall Perry, who will be covering Mahmoud versus Taylor. Sarah Parshall Perry is the Vice President and Legal Fellow at Defending Education, formerly Parents Defending Education. Sarah was a Senior Legal Fellow in the Edwin Meese Center for Legal and Judicial Studies at the Heritage Foundation before joining Defending Education. Sarah joined Heritage after serving as Senior Counsel to the Assistant Secretary for Civil Rights at the U.S. Department of Education. Before that, Sarah was an in-house counsel and Director of Development for a Baltimore advertising agency. She holds a law degree from the University of Virginia School of Law. She holds a BS in journalism with honors from Liberty University. Fifth, we have Gregory Sisk, who will be covering Martin versus United States. Professor Gregory Sisk is the P.O. Cardinal Logie Distinguished Chair in Law at the University of St. Thomas School of Law in Minneapolis, Minnesota. He received his BA from Montana State University and his JD from the University of Washington School of Law, where he graduated first in his class, was an editor on the Law Review, and president of the Moot Court Board. Prior to joining the Legal Academy, he served as a legal advisor in all three branches of the federal government, as a legal assistant to a U.S. senator, as a law clerk to a U.S. Court of Appeals judge, and as an appellate attorney with the U.S. Department of Justice, representing the United States in the Courts of Appeals and the Supreme Court. Subsequent to his government service, he was in private practice as the head of the appellate department of a Seattle law firm. Six, finally, last and certainly not least, we have Tim Rosenberger, who will be covering Oklahoma Charter School Board versus Drummond. Tim Rosenberger is a legal fellow at the Manhattan Institute. Previously, he was a legal policy fellow at the Cicero Institute, a parish pastor, and a management consultant with McKinsey & Company. He holds an AB from Georgetown University, an MDiv from United Lutheran Seminary, a DMin from the Rollins School of Divinity, an LLM from a school in Germany, whose name I can't pronounce, and a JD MBA from Stanford University, where he was Federalist Society chapter president and served on the Law Review. Tim's research interests lie at the intersection of law, faith, education, and entrepreneurship, with a particular focus on leveraging policy to help America's overlooked populations create lives of dignity. With that, I'm going to go ahead and turn things over to our panelists. We are going to begin at the beginning with our first case for Monday, April 21st. After that, we're going to jump to Wednesday, April 23rd, for a discussion of Diamond Alternative Energy versus EPA. To kick things off, I'm going to ask Thomas Berry to join us.
All right. Well, thank you so much. It's an honor to be asked. I've got two cases to get through, so I'll jump right in. And I also, just to let the viewers know, due to a prior commitment, I'm probably going to have to jump off the call before the Q&A portion at the end, so I apologize for that. So to start with the very first case of this sitting, Kennedy versus Braidwood Management. The Affordable Care Act requires private health insurers to cover certain preventive care treatments without any cost sharing, but the statute does not specify which preventive care treatments insurers must cover. Instead, the law delegates this decision to a 16-member body called the U.S. Preventive Services Task Force. Under the ACA, the task force makes recommendations as to which preventive services must be covered. If the task force recommends that a service be covered, the statute says that insurance plans shall, at a minimum, provide coverage for that preventive service. This case began when several individuals and small businesses sued the government, objecting to certain preventive service coverage requirements on several different grounds. Now, up at the Supreme Court, the key question is whether the 16 members of the task force were properly appointed. The Constitution requires, as a default rule, that officers of the United States must be nominated by the President and confirmed by the Senate. But if an officer is merely an inferior officer, Congress may waive Senate consent. Even then, Congress is limited to only three choices for who may appoint that officer: the President alone, the heads of departments, and the courts of law. And Congress must make that choice to waive Senate consent by law, or in other words, by passing a statute. Finally, if a government official is not an officer at all, then that official is what's called a mere employee, and that official may be appointed by anyone. So what are task force members? Are they mere employees, inferior officers, or non-inferior officers, also known as principal officers. Since the creation of the task force, its members had been appointed by an official ranking below the cabinet level, below the head of department level. The task force was originally created in 1984 as a purely advisory body. It wasn't given any substantive power over federal policy until the ACA was passed in 2010. So there's no dispute that task force members were indeed mere employees, at least from 1984 to 2009. And it's understandable that simple inertia led the government to assume that they remained mere employees after 2010. But then this lawsuit was filed, challenging the status of task force members. And after the government lost in the district court, it conceded that task force members are officers, not mere employees. Last year, the Secretary of HHS ratified the appointment of the 16 members of the task force, effectively purporting to appoint them himself. But on appeal to the Fifth Circuit held that task force members are principal officers, not inferior officers, meaning even an appointment by a department head is not sufficient. What's the difference between a principal and inferior officer? In the 1997 case Edmund versus United States, the Supreme Court held that inferior officers are officers whose work is directed and supervised at some level by a Senate-confirmed officer above them. The Supreme Court pointed to 3 factors that help determine whether officers are directed and supervised. Are they removable at will? Are their decisions reviewable by a higher up? And are they subject to day-to-day supervision? In this Braidwood Management case, the Fifth Circuit held that task force members are removable at will by the HHS Secretary, but the Fifth Circuit also held that their decisions are not reviewable by the HHS Secretary. So the Fifth Circuit was presented with a mixed bag. On one factor, they were controlled, but in another factor, they were not. And presented with this mixed bag, the Fifth Circuit held that reviewability is the more important of these 2 factors. And on that basis, the Fifth Circuit held that task force members are principal officers, and that thus they were appointed unconstitutionally. Now the case is at the Supreme Court. The government argues that the Secretary of HHS does have the authority to veto the task force's decisions. The government points to a statutory provision authorizing the Secretary to supervise and direct the agency that houses the task force. In the government's view, the power to direct the task force includes the power to prevent a task force recommendation from taking effect. In response, Braidwood Management, the lead challenger to the task force, points to another statutory provision, holding that task force members and their recommendations shall be, quote, independent and to the extent practicable, not subject to political pressure. Braidwood argues that this means task force recommendations are not reviewable, and Braidwood argues that task force members are not removable at will. Finally, Braidwood argues that even if task force members are inferior officers, Congress did not pass a statute designating the HHS Secretary as their appointer. That means Congress has not made the required decision to exempt them from Senate consent, so the default rule still applies. They would need to be nominated by the president and confirmed by the Senate. All right, and moving on straight through to the second case I'll be discussing, Diamond Alternative Energy versus EPA, which will be argued on Wednesday of next week. The Clean Air Act broadly preempts states from adopting their own motor vehicle emission standards. But the Act permits California and only California to obtain waivers from federal preemption. Congress granted California this special status because of the state's unique problems with smog and other local environmental issues. To receive a waiver, California must show that it needs that waiver to, quote, meet compelling and extraordinary conditions. If a waiver is granted, other states may either apply EPA's standards or adopt California's, but they may not set their own. In 2022, EPA granted a waiver for California's Advanced Clean Cars program. That program requires, among other things, that a certain minimum percentage of Model 2025 cars sold in California must be zero-emission vehicles. This waiver was soon challenged in court by a group of entities that produce or sell liquid fuels and the raw materials used to make liquid fuels. On the merits, They argue that the waiver was improper because the Clean Air Act only allows exemptions for problems localized to California, like smog, not for global issues like climate change. But the case has not reached the merits. The D.C. Circuit held that all of these challengers lacked Article 3 standing. The court held that the challengers had failed to demonstrate that automakers would indeed sell more fuel-burning cars if the waiver were set aside. Thus, the court held that they had not shown that a favorable decision would redress their economic injuries. Now the case is at the Supreme Court, where the liquid fuel producers have presented two alternative tests under which the Supreme Court could find that they do in fact have standing. First, the petitioners argue the court should adopt a categorical rule that redressability is satisfied when a favorable decision would, quote, remove a regulatory hurdle to the sale of a party's products. Second, the petitioners argue that challengers to a government action should be able to establish redressability by relying on the action's predictable effect on third parties. In this case, even though automakers are the direct target of this regulation, the predictable effects of the regulation extend to the producers of the fuel used by non-electric cars. Petitioners argue that California's standards push the electric car market beyond what consumers would ordinarily demand and beyond what automakers would ordinarily produce and sell. After all, that's the point of the standards. For that reason, petitioners argue it's not just predictable, but obvious that allowing California to limit vehicles' emissions will result in less fuel consumption. As the petitioners point out, it's difficult to imagine that the parties would have litigated this case for 3 years if the waiver might not reduce liquid fuel consumption by even $1. In response, the government argues that automakers may well have changed their behavior due to the waiver, but that does not necessarily mean they would change their behavior back if the waiver were set aside. The government points out that 2022 was not the first time this waiver was granted. It was first granted back in 2013, it was revoked in 2019, and it was reinstated in 2022. That means that automakers have been adjusting their behavior to comply with the waiver for over a decade. During that period, manufacturers have made significant investments in updating their fleets and growing consumer demand for electric vehicles. The government points out that many automakers have stated that they plan to sell more electric vehicles in the future than would be required by California's Advanced Clean Car Program due to market forces and long-term investment decisions. In the government's view, the burden was on the petitioners to show that a decision in their favor would likely cause at least one manufacturer to alter its prices or products in a way that would increase demand for liquid fuels. The government points out that the petitioners did not identify any such manufacturer when they sought to prove their standing below, and they still have not named a candidate. In the government's view, requiring petitioners to identify a specific automaker and explain why it would likely change its behavior is not too much to ask. Put simply, the government concedes that automakers might not have produced as many electric cars had the waiver never gone into effect, but the government suggests that now it may be too late for a decision setting aside the waiver to change the rate of production of electric cars going forward, and thus it may be too late for such a decision to do any good for the petitioners. Thank you.
Thank you very much, Thomas. We are going to now turn things over to Professor Fitzpatrick, who is going to start with a case that will again be argued on Monday, April 21st, Parrish versus United States, after which he will jump ahead to Tuesday, April 29th to discuss LabCorp versus Davis. Professor Fitzpatrick, I invite you to give your remarks.
Thank you so much. It's an honor and a pleasure to be here today. I'm the civil procedure professor, so they gave me the civil procedure cases, and I don't mind that at all. The first case, Parrish versus United States, is a question of appellate procedure. The case is out of the Fourth Circuit, and it involves prisoner litigation. And it involves a question presented that probably will not occur to any litigants except for pro se litigants like prisoners. So it has, I would say, a limited scope of consequences, but it's actually a very interesting question of statutory interpretation that the court has before it. What happened in this case was that a prisoner filed a lawsuit contending that he was mistreated in his prison, and his complaint was dismissed by the federal judge, but he didn't get a copy of the judgment dismissing his complaint because he was in transit between two different prisons. By the time he got the copy of the judgment, the 60-day period to appeal had expired. He filed a notice of appeal anyway, even though it was late, and he explained why it was late. And the Fourth Circuit decided to treat this late notice of appeal as a motion to reopen the time to file an appeal. And that's allowed under the jurisdictional statute 28 U.S.C. 1207, as well as the implementing Federal Rule of Appellate Procedure 4. The district court's allowed to reopen a period to file a notice of appeal in certain circumstances, including that you never got a copy of the judgment in time. So that's what the district court did. The district court reopened for 14 days the period to file a notice of appeal, but the plaintiff, Parrish, did not file another notice of appeal during that period. He just went about his merry way, and the question in the case is whether you have to file another notice of appeal, a timely, proper notice of appeal, when your time to file the notice of appeal is reopened, or whether the untimely one that you previously filed can be credited during this new reopened time period. Interestingly, the federal government, who's the defendant here, agrees with Parrish that you should get credit for a previously but untimely filed notice of appeal. But the Fourth Circuit disagreed. The Fourth Circuit held that this statute 28 U.S.C. 1207 is a jurisdictional statute. They can't monkey around with the statutory jurisdiction of the Court of Appeals, and you have to turn sharp corners when you're dealing with jurisdiction, and you have to file a timely notice of appeal once your period is reopened. The Fourth Circuit is apparently an outlier in that regard. There are several other circuits that have said, no, if you've previously filed an untimely notice of appeal, you get credit for it once the period reopens. So the Supreme Court granted cert to resolve this circuit split. Like I said, the United States agrees with the petitioner Parrish that his petition, his appeal should have been considered timely. So the Supreme Court appointed an amicus to defend the view of the Fourth Circuit. The amicus is someone named Michael, I don't know if it's Houston or Huston. He's at Perkins Coie in Arizona, a former law clerk to the Chief Justice, John Roberts. My initial inclination about this case was, can't we just do what we normally do for pro se litigants, and that is bend over backwards for them? Courts often say we're going to construe things in their favor as much as we can in order to serve the interests of justice. But, the Supreme Court has said that the time to file a notice of appeal is a jurisdictional matter, and that the Court of Appeals cannot expand their own jurisdiction. Only Congress can do that. And so it's hard to bend over backwards when we're dealing with jurisdiction. So what does this statute says? Well, the statute really doesn't say anything at all about whether an untimely notice of appeal that was filed prematurely can be credited as timely once the period is reopened. All it says is that the district court can reopen the period for 14 days. And, you know, we can have a debate, I guess, about whether the word reopen suggests something that you have to file another notice of appeal or not. You know, that's a matter of textual interpretation. Doesn't seem super clear to me that the word reopen excludes the possibility that your previously filed notice of appeal could be credited. A complication here is Federal Rule of Appellate Procedure 4, which largely just repeats what 1207 says. This rule goes on to embellish what 1207 says a bit, and this rule says sometimes your prematurely notice can be credited as a notice of appeal once the period opens. So the rule kind of directly addresses this situation, but it doesn't address the situation in the context of this particular petitioner. It doesn't address it in the context of a reopened period. It says, for example, if you file your notice of appeal before there is a judgment, it counts as a notice of appeal once there is a judgment and the period to appeal starts. So you filed it before the period starts. That's okay, the rule says, but it doesn't say anything about the reopening situation. It just talks about a notice of appeal filed before judgment. So, you know, there are arguments, kind of like an expressio unius argument. The rule talks about premature notice of appeal in one context, but not another. That means you can't get the credit of the premature notice of appeal in the other context. The problem with this expressio unius point is that this is all about Rule 4. It's not about 1207. And 1207 is really what the important text is, because that's what Congress said about the jurisdiction of the courts. Rule 4 is to some extent what the courts are saying about their own jurisdiction, and the courts can't go beyond what Congress has said their jurisdiction is. The government's brief says that we should interpret the text of 1207 to credit these premature notices of appeal because that was the judicial practice at the time 1207 was enacted. I think it was 1991 or thereabouts. Its current form, the provision of 1207 about reopening, 1207C, I believe that was 1991. The judicial practice at the time was to really credit premature notice of appeals in all contexts. And so we should assume that the text was adopted against that background and that the same rule carries through now that the text is on the books. So we'll have to see how those textualist arguments fare before the court. That's all I have to say about the Parrish case. Like I said, I think the consequences are fairly narrow because I think probably only the pro se litigants will fall into the category of people that may not know what the particular rule is in their circuit on this question. I will note that the petitioner's brief said that half, I could hardly believe this, half of all appeals filed in the federal system are by pro se litigants. So the petitioner says, even though it only affects us pro ses, perhaps it's important because it could affect up to half of all of the appeals in the federal system. Let's shift gears, if we may, to the other civil procedure case I want to talk about. This is the LabCorp v. Davis case. It's out of the Ninth Circuit. It's not being argued next week, as we were told. It's being argued the week after. This one is a very important class action case, and it presents a very sexy class action issue. And the issue, which has been, bandied about for years and years and never decided, is whether you can certify a class action if some of the members of the class are not injured. And, the arguments that you can't certify a class when some class members are injured. They are found in two places. One place is Article 3 of the United States Constitution. Article 3 requires that there be a case or controversy before the federal court. And the Supreme Court has said that that means that the plaintiff has to have an actual injury. And if the class is certified with some people that don't have an actual injury, the argument is it's no longer a case or controversy. You have uninjured people that you are adjudicating, and the court loses Article 3 jurisdiction once there's an uninjured person in a certified class. The other place the argument is made that you can't have uninjured members is with regard to Rule 23b3. That is our rule about certifying class actions for money damages. And 23b3 says you cannot certify a class if the individual issues predominate over the common issues. And the argument is you're going to have to sort out at some point which class members are injured and which class members are not. You're going to have to sort that out when you're giving damages to the class members, when you're distributing the damages. And so that is going to be a big mess. And therefore, the common issues do not predominate over the individual issues. Those are the arguments that are made. This particular case is an Americans with Disabilities Act case on behalf of blind class members who say that they could not use LabCorp's services because LabCorp started checking in patients using kiosks, little like iPad kiosks, and they couldn't see the kiosk, and so they couldn't check in with the kiosks. And so the district court certified a class of blind customers of LabCorp. And LabCorp assumes that there are some uninjured class members in this class because not every blind person wanted to use a kiosk, they say. And therefore, there's some people in this class that were not injured at all. And the district court should not have been able to certify it. There's been a variety of different opinions in the Court of Appeals about certifying classes with uninjured class members. Most courts have said it's fine, but it depends upon how many uninjured class members there are, et cetera, et cetera. So the court took the case to try to resolve what the final answer is on these uninjured class members. The problem with this particular case is we don't actually know whether there are any uninjured class members or not. LabCorp says there are. No one has ever established that. I guess LabCorp's view might be that it's the burden of the plaintiffs to prove that every class member in the class they want to certify has been injured. So once LabCorp says, we think some of you are not injured, then it becomes the burden on the plaintiff to prove that every class member is injured. Of course, that'd be very hard for the plaintiffs to do because the plaintiffs don't even know who all the class members are, right? We certify class actions all the time without a list of who the class members are. So if that position gets adopted by the Supreme Court, that basically the plaintiffs have to prove every time they want to certify a class that every single class member has standing, every single class member is injured, that's going to really put a damper on class action litigation. I think that could be a very profound outcome here. I'm not sure that's what's going to happen here because, as I noted, it's not even certain whether any class members have been uninjured here. And so the respondents, the class, has asked the Supreme Court to dismiss this case as improvidently granted, that in fact there's no reason to think that any class members are uninjured. The class that the district court certified said that you had to be a blind person who had gone to one of the LabCorp offices and were denied access on equal terms to non-blind people. And so, you know, the class members say everyone in that class is injured. If you've been denied equal services, you're injured. So we don't really know what the heck LabCorp is really complaining about here. So they're arguing to dismiss this thing as improvidently granted. And that I could see possibly happening. I think it would be pretty adventurous for the court to adopt LabCorp's rule kind of as a hypothetical matter in a situation where we don't even know whether there are any uninjured class members. I will say, though, the government does support LabCorp. Technically, they're not supporting either party, but the government does support LabCorp's rule, which is you can't have any uninjured class members at the stage of certification. If the class members say you can have uninjured class members, you just need to sort it out later when you're actually distributing the damages. And that happens all the time in class actions. We certify class actions all the time when there's going to be individualized questions on damages if we actually get to a trial. And so there's nothing different about that here. That's also the position taken by Arthur Miller, who filed an amicus brief, again, technically in support of neither party, with Bill Rubenstein, a professor at Harvard. And that's their position as well, which is as long as someone has standing, the court does not lose Article 3 jurisdiction because there are some people joined to the case who don't have standing. And we can sort all this out later if we have to distribute damages after a trial. So we'll see what happens there. You know, I was hoping, just my last point, then I'll turn it back over to our moderator, but I was hoping that this case might present some opportunities for an originalist reexamination of the Supreme Court's standing doctrine, because this actual injury requirement that the court has read into Article 3, a lot of originalist scholars think is completely made up, and that in fact, if Congress gives you a personal statutory right, that you should be able to go to federal court to vindicate those rights, even if you don't meet the actual injury requirement. And so there's been a lot of originalist scholarship on this now. People like Bob Pushaw at Pepperdine, Jim Fander at Northwestern are saying things like this. Justice Thomas has picked up a little bit of this in some of his separate opinions in these class action standing cases. And I was hoping this case might be a vehicle to re-examine some of those doctrines, but the way it's been briefed, I don't think it will. It seems like it's going to be a straight up question on current doctrine rather than a re-examination of it, which I think is too bad. But maybe that re-examination will happen another day. Thank you so much.
Thank you, Professor Fitzpatrick. We are now going to leap back from Tuesday the 29th to Tuesday the 22nd, beginning with Commissioner of Internal Revenue versus Zuck. And to introduce that case to us, I would like to invite Ms. Ugolini to the floor.
Thank you. Okay, so Commissioner versus Zook is about whether a particular type of tax court proceeding is moot, which ultimately turns on the scope of the tax court's jurisdiction and what type of relief it can award under the Internal Revenue Code. So just backing up, for any viewers who may not know there actually is a tax court, the tax court is an Article I court that was created about 100 years ago to hear certain types of prepayment tax disputes. District courts have general jurisdiction over tax cases, but a taxpayer has to fully pay the tax first and then sue for a tax refund. So as I mentioned, the tax court is a prepayment forum, and it also has more streamlined discovery, and the cases are decided by a judge. So the tax court is in many ways an easier forum to access for individuals and small businesses, but its jurisdiction is very limited. For example, you generally can't get a tax refund in the tax court. So going back to the Zook case, the respondent, Jennifer Zook, self-reported on an amended tax return that she owed additional tax, but she also claimed that she had prepaid this tax through estimated tax payments that she had sent in with her ex-husband. Well, the IRS disagreed because it had already applied the estimated tax payments to her ex-husband's account. So it determined that she had a balance due based on her amended return. The respondent didn't pay the balance due, and the IRS then sought to collect the balance by levy, which is basically seizing a taxpayer's property to collect a tax, such as proceeds in a bank account. So this entitled the respondent to a statutory pre-levy hearing in the tax court under 26 U.S.C. 6330. And in that hearing, the tax court can consider a broad array of issues relating to the proposed levy. So while the tax court case was pending, the respondent overpaid her taxes for other years, and the IRS exercised its authority under yet another provision of the Internal Revenue Code to apply those overpayments to her balance due rather than issue her a refund. So the IRS was actually able to fully collect the unpaid balance this way, leaving no balance due and no need anymore for a levy. The tax court dismissed the pre-levy proceeding as moot, given that there was no levy on the table anymore. So this case went to the Third Circuit, which reversed, creating a split with the DC and Fourth Circuits, which had held that a pre-levy proceeding is moot when the IRS no longer seeks to levy, even if there are still underlying disputes with the IRS. The Third Circuit also held that the tax court has implicit jurisdiction to review the IRS's offsets, the withholding of the overpayments and application to the balance due. And the Third Circuit thought the offsets here were illegal, and so the case was not moot. So in the Supreme Court, the government, which is the petitioner, argues that the statute creating this type of tax court proceeding limits the relief to just an up or down determination whether the IRS can proceed with a levy. So if there is no levy being proposed anymore, there is nothing for the tax court to decide. In the government's view, if the respondent thinks the IRS collected too much from her because she should have gotten the benefit of the estimated tax payments, she can now bring a refund suit in the district court, and in fact, the respondent recently filed one. The government also contests that the tax court has any jurisdiction to review the IRS's offsets. So the respondent argues that even if the IRS is not seeking to levy anymore, the tax court still has jurisdiction to decide subsidiary live issues that were underlying the proposal to levy in the first place. In this case, whether the IRS properly applied the estimated tax payments. In her view, the tax court can issue basically a declaratory judgment on that underlying dispute, which the IRS would then have to honor by issuing a refund, even though the tax court itself doesn't have jurisdiction to order a refund. So ultimately, this is a case about statutory interpretation, with both parties parsing the statutory text to make their respective arguments regarding the scope of the tax court's jurisdiction under this statute. For tax administration, the case has significant implications. Because the tax court is an easier court for taxpayers to access, taxpayers have pushed to expand the scope of the court's jurisdiction through litigation, and they've had some success, particularly in the area of whether particular statutes are jurisdictional or claims processing. On the government side, one of the issues that was really driving this case was the Third Circuit's unprecedented holding that the tax court had implicit jurisdiction to review the IRS's statutory offsets. And actually, the respondent does not defend that ruling in the Supreme Court. The IRS processes hundreds of millions of returns each year, and it relies heavily on its statutory offset power for efficient collection of taxes. So the Third Circuit's judgment on that issue, if left standing, would seriously cripple an important tax collection tool. So we'll wait to see what the court decides. Thanks.
Thank you very much. We'll continue with the second case to be argued on Tuesday, the 22nd, with Mahmood versus Taylor. And to introduce that case, Sarah Perry, I would like to invite you to give your remarks. Sarah, I think you might be muted. Sarah, could you try maybe unplugging your AirPods or your headphones?
Yes. Can you all hear me?
Amazing.
Wonderful. Well, trying to be helpful, but of course, best laid plans. I will endeavor to be brief but thorough. This is one of 3 cases, actually, that will address questions of education and education law, and one of 2 cases that's at the intersection of religious liberty and public education. On January 17th, the Supreme Court took up what many are saying is sort of a culture war implication case. We've already seen porn in the First Amendment. We've seen ghost guns. We've seen so-called gender affirming care for minors. This goes to the question of whether or not a group of religious parents have a right to know what their child is being taught and to opt out their children from such curriculum if it is an offense to their religious beliefs. This is concerning the Montgomery County Board of Education. It is the largest school district in Maryland. And what they included was material for 3 and 4-year-olds, including relative to LGBTQIA plus themes. These were children who were as young as 3 and 4 years old. Now, we know that parental litigation over school policies is often rooted 9 times out of 10 in the Supreme Court's substantive due process analysis, dating all the way back to Meyer versus Nebraska in 1923. And relative to this case, the most specific application is going to be Wisconsin versus Yoder, a 1972 case in which the Supreme Court invalidated a state law requiring children to attend school beyond the 8th grade, holding that it violated the free exercise clause of the First Amendment by interfering with the parents' constitutional right to direct the religious upbringing of their children. Multiple times we've seen the Supreme Court weigh in on the fact that, as many of us can repeat now by memory, it is the exclusive purview of the parent to direct the upbringing and education of their own. But there are some categories of educational decisions in which parents do not have a cognizable constitutional interest. For example, parental rights, as traditionally recognized by the Supreme Court, are comparatively weaker in matters of substantive curriculum or school administration. Specifically, the Supreme Court's recognized that, notwithstanding a near absolutist pronouncement, we have also recognized that for portions of the day, children are in a compulsory custody of state-operated school systems. And in that setting, the state's power is custodial and tutelary, permitting a degree of supervision and control that could not be exercised over free adults. So matters, for example, of curriculum or school administration, stop and end times for the school day are generally out of the realm of constitutional challenge by parents. Curricular opt-out rights are generally governed by state and local policies and are generally limited to narrow categories of instruction, specifically on sex education. 47 states and the District of Columbia, for example, allow parents to opt out of sex education curriculum, but no state has gone so far as to bar opt-out overall. Critically here, the Montgomery County Board of Education originally allowed parents a right of opt-out, and then 2 years later reversed without explanation, not only eliminating the curricular opt-out right, but the informational right for parents to know when exactly the materials were going to be presented to their minor children. So in a situation where classroom instruction clashes with religious belief, does the school or the parental interest prevail? The petitioners in Mahmoud are a multi-faith group of parents. They are Christian, Orthodox Jews, and Muslims, and they're not challenging critically the Montgomery County curriculum itself. I think it's been unfairly categorized in some media publications online that this is a book ban case, or this is a so-called don't say gay type of a case. In fact, it is not. They are not challenging the curriculum itself or the presentation of that curriculum. Only their right as parents to be able to be notified of and opt out their children from such instruction. Their argument is that the district's compulsion of their elementary school-age children to participate in instruction contrary to their religious convictions violates the Free Exercise Clause. And the U.S. Court of Appeals for the Fourth Circuit below very narrowly construed Wisconsin v. Yoder, finding that no free exercise burden had transpired because no parent or child had been forced to change their religious perspectives, beliefs, or conduct. Now, that holding conflicts with the Supreme Court's extensive First Amendment jurisprudence on religious exercise and with the plain black letter law of Wisconsin versus Yoder itself, which held that the, quote, fundamental interest of parents to guide the religious future and education of their children is now established beyond debate, end quote. So the Supreme Court's decision is going to settle a significant circuit split on this very highly contentious issue, especially in an era of continuing discord over the parameters of what parental rights look like in practice, and especially so within the context of public education. 5 federal circuits hold that forced participation in public school instruction cannot alone burden free exercise absent some coercive effect, and that Wisconsin v. Yoder presents parents with no protection for their religious beliefs once they place their children in the public school system. But the Eighth Circuit stands alone in holding that forced participation in public school instruction can by itself burden religious liberty under the Free Exercise Clause. Now, in dissent from the Fourth Circuit Court of Appeals determination in the Mahmoud case, Judge Quattlebaum recognized that the decision to deny parents in Mahmoud a preliminary injunction, quote, burdening the exercise of religion is not just limited to direct coercion. Religious liberty can be infringed by the denial of or placing of conditions upon a public benefit or privilege, end quote. So Montgomery County Public Schools' no opt-out policy forced parents, as Quattlebaum wrote, to either live out their beliefs or forego the public benefit of education altogether. So this will certainly be not only a highly contentious outcome, whatever it is, but it is certain to garner national attention, as it already has, and will be argued this coming Tuesday, the 22nd. Thank you.
Thank you very much, Sarah. We're going to be jumping ahead now back to Tuesday, April 29th, when we'll hear Martin versus United States. I'm going to invite Professor Sisk to describe that case for us.
Good morning. Good morning. And it is still morning out here in Minnesota. Martin versus United States will be argued on Tuesday, April 29th, and I should begin by way of full disclosure in saying I have filed an amicus brief in this case on the Supremacy Clause question, represented by the wonderful folks at Brian Cave, and in particular Jeff Pipoli and Matt Stanford. The Martin family's cause has been taken up by the great folks at the Institute for Justice. And in the interest of time, I'm going to focus my attention solely on the Supremacy Clause issue that's before the Supreme Court in this case. So this is a tale about an innocent family's nightmare. In the middle of the night, this family of 2 adults and a child were asleep in their suburban Atlanta home. Unbeknownst, I love that word, it adds a sense of mystery to every story. Unbeknownst to this family, a team of federal law enforcement agents was preparing a raid on a nearby home to execute a warrant on a suspected gang member who was believed to be armed and dangerous. A team leader led the group to the targeted house using an app on his phone for directions. The federal agents breached the door into this family's home, throwing in a flashbang. The man and woman had hidden in a closet, thinking this was an armed robbery. The man was dragged from the closet, handcuffed, and thrown to the ground while guns were pointed at the woman. At some point, an officer saw the man's driver's license and realized they were in the wrong house. So as it happens, this was hardly the first time that an episode like this had occurred. Almost exactly 50 years ago, federal narcotics agents had similarly raided 2 houses, traumatizing the families, only to discover that they had entered the wrong house. Now, a federal statutory waiver of sovereign immunity, the Federal Tort Claims Act, enacted in 1946, would be the logical source of a remedy. But the victims of the mistaken raids half a century ago discovered that they could not obtain relief from the federal government through the Federal Tort Claims Act. At that time, the statute barred any claim arising from such intentional torts as assault and battery, false imprisonment, etc. But Congress was outraged by these episodes, and in 1974 enacted a special proviso to the statute known as the Law Enforcement Proviso. This specifically allows victims of law enforcement wrongdoing to bring intentional tort suits under the Federal Tort Claims Act. Still, here we are 50 years later, and according to the 11th Circuit, the federal government is still immune from liability under the FTCA for a mistaken house raid. Unique to that circuit, the 11th Circuit holds that even when sovereign immunity is specifically waived by Congress through the Federal Tort Claims Act and here through the Law Enforcement Proviso, the Supremacy Clause of the Constitution operates independently to protect federal law enforcement from liability whenever its actions might implicate policy. To put it bluntly, this is an oxymoronic ruling by the 11th Circuit. Now, the Supremacy Clause states that, quote, "This Constitution and the laws of the United States which shall be made in pursuance thereof, etc., shall be the supreme law of the land." If Congress has specifically provided for liability through a statute, then that law of the United States is what counts as the supreme law of the land. It is illogical to say that a duly enacted federal statute can violate the Supremacy Clause. And indeed, the government decided not to defend the 11th Circuit's reasoning, so an amicus has been appointed to defend this aspect of the ruling. And importantly, the FTCA contains its own protection of federal policy in the text of the discretionary function exception. But that statutory policy is defined and limited. Unfortunately, the lower federal courts have developed a sweeping approach to the discretionary function exception that grants policy immunity to the federal government whenever one can imagine a policy justification. By this mistaken doctrine, the United States government escapes accountability for even simple neglect by after-the-fact speculation about policy factors that could have played a role, but actually did not, in the government's conduct. And that describes this very situation. The government admitted below it had adopted no policy on how federal agents identified the correct house for a law enforcement raid. The very text of the statute allows immunity under the FTCA only when the government decision was, quote, based on, that is, causally linked to, a, quote, discretionary function, which is a term of art that means an actual policy judgment. Moreover, the Supreme Court has said that the purpose of the exception is to prevent second guessing of public policy decisions. But the risk of judicial intrusion into federal policymaking vanishes when government officials have never exercised policy judgment. My amicus brief, as well as a recent article I published just a few weeks ago at 100 Notre Dame Law Review 729, sets out the full doctrinal and statutory text reasons why the federal government should not get imaginary policy immunity under the discretionary function exception. Now, I should say that in this Martin case, the government insists that the court should not reach the question of the meaning of the discretionary function exception because it is not within the directed question on the Supremacy Clause. But in my view, a key reason why the Supremacy Clause cannot be applied to grant policy immunity here is precisely because the specifically defined and circumscribed policy protection of the statutory discretionary function exception already controls the field. And so we'll see what the court does.
Thank you, Professor Sisk. Rounding out the batting order, we have on Wednesday, April 30th, Oklahoma Charter School Board versus Drummond. And to help us understand that case, we have Tim Rosenberg.
Well, thanks for having me on. In this case, the question presented is whether the Free Exercise Clause prohibits the state from categorically excluding religious. Okay. Oh.
Tim, we had you and then we lost you.
I've just got like a message. Do you guys see and hear me?
We can hear you now.
Great. So we're asked whether the Free Exercise Clause prohibits a state from categorically excluding religious organizations from operating charter schools solely because they are religious. The Archdiocese of Oklahoma City and the Diocese of Tulsa proposed a statewide virtual charter school that would provide an authentically Catholic education to Oklahoma students. This was particularly important because of the geography of Oklahoma. They really wanted to focus on rural students who live in areas where Catholic schools are scarce. The school they created, St. Isidore, satisfied all neutral, secular charter criteria. Nonetheless, Oklahoma law, like the law in many states, prohibits charter schools from being religious. These laws, and in many cases state constitutional provisions, often known as Blaine Amendments, are rooted in pervasive anti-Catholic bigotry from more than a century ago. The dioceses contend that Oklahoma's exclusion violates the Free Exercise Clause. Oklahoma's charter school board agreed with them and approved St. Isidore's application. In response, the Oklahoma Attorney General filed suit, and the Oklahoma Supreme Court held that a religious charter school would violate the state constitution. The Supreme Court has granted review. The constitutional claim that St. Isidore is bringing aligns with the court's recent free exercise decisions in Trinity, Lutheran, Espinoza, and Carson. In those cases, the court held that while states are not obligated to subsidize private education, once they choose to make public benefits available through private actors, they can't exclude participants because of their religious identity or demand that they secularize as a condition of participation. That principle applies directly to Oklahoma's charter system. Charter schools in Oklahoma are publicly funded but privately operated. They are governed by independent boards, not school districts. They are permitted to pursue distinctive missions. The state's approved schools that focus on Montessori education, STEM-focused instruction, even programs centered on Native American language and culture. Yet the one distinctive mission that is categorically excluded is religion. That exclusion is not neutrality, it is unconstitutional discrimination. The argument that charter schools are public schools in the same sense as traditional government schools is overstated. While states label charter schools as public for funding purposes, they are not run by the government. They are created and operated by private actors under contract with the state. That fact distinguishes this case from cases involving government-run schools and aligns it instead with other public-private partnerships. Think religious hospitals participating in Medicaid, or religious universities that receive Pell Grant funding. Some warn that a ruling for St. Isidore could cause states to retreat from charter authorization altogether. But compliance with the Constitution is not optional. The state may not maintain a public benefit program on the condition that it discriminate on the basis of religion. Others argue that religious groups should stick to private school choice programs, such as vouchers or ESAs. That may be a reasonable policy preference, but it is not a constitutional justification for excluding religious groups from chartering. As Professor Nicole Stell-Garnett has observed, that's a prudential question, not a legal one. This case is not about school prayer, religious instruction in district-run schools, or establishing official religions. It's about whether religious organizations can participate on equal terms in a public benefit program designed to expand educational opportunity. In that sense, St. Isidore is not requesting special treatment. It is requesting equal treatment under the law. We should note a sort of interesting thing that's been in the news about this case. Justice Barrett has recused herself, but nonetheless, given recent decisions from the court, I'm sort of expecting St. Isidore to prevail here. And assuming that happens, it remains to be seen what the implications are for state chartering programs and school choice more broadly. But again, those aren't constitutional questions, and it's pretty clear how this one should shake out. Thank you.
Thank you very much, Tim. I'm going to cover two cases, and while I do that, I'm going to invite everyone to think of questions and use our Q&A feature to type those out so that I can ask our panelists. We'll have about 15 or 20 minutes for questions once I'm done. I'll just take a minute or two with these cases. These are two cases that will be argued on Monday, April 28th. The first is AJT versus Osseo Area Schools. This is another education case on the Supreme Court's April docket. This one concerns the American with Disabilities Act and the Rehabilitation Act. Title II of the ADA and Section 504 of the Rehabilitation Act require public entities and organizations that receive federal funding to provide reasonable accommodations for people with disabilities, and that includes in schools. Ava is a student with epilepsy who started middle school at Osseo Area Schools. Her parents said that the school district limited Ava's instructional time to less than half the time her peers were receiving. They brought claims under the ADA and the RA. The Eighth Circuit held that a school only violates its anti-discrimination requirements under these statutes if school officials acted with bad faith or gross misjudgment, and further held that Osseo area schools did not rise to this standard. Now, Ava says on appeal to the Supreme Court that this test of bad faith or gross misjudgment only applies in school settings in the Eighth Circuit, and that this standard is not applied outside of the school context. The school district says that Congress usually speaks very clearly when it compels affirmative actions or authorizes intent-free, reasonable accommodation or disparate income impact claims, as it does in other provisions of the Rehabilitation Act and the ADA. The United States filed an amicus brief in Ava's support, arguing that the Title II and 504 standards should be the same in the educational context as outside of it. The second case that will be argued on Monday, April 28th, is Soto versus United States. This is a case involving combat-related special compensation, or CRSC, which is a monthly benefit authorized by Congress for veterans who have been disabled by combat. Corporal Simon A. Soto is a Navy retiree who applied for prospective CRSC benefits. He also applied for 8 years' worth of retroactive payments. Everyone agrees that CRSC payments can be retroactive, but the Department of Defense settled Corporal Soto's claim, but limited his retroactive benefits to 6 rather than 8 years. In doing so, the DoD invoked the Barring Act, which imposes a 6-year statute of limitations on claims against the government. Soto's arguments to the Supreme Court is that the CRSC statute displaces the Barring Act and its 6-year statute of limitations because it authorizes settlement of CRSC claims, which is the kind of feature that would usually displace the Barring Act and impose a unique set of statute of limitations requirements. The government says that the Barring Act controls. There is a 6-year statute of limitations from the Barring Act, and the CRSC doesn't do anything to unsettle that statute of limitations. Why? Because, according to the government, when Congress has intended to displace the Barring Act in the past, it has done so expressly, usually by using language like the word settle, in terms of settling a category of claims, or by specifying alternative timing rules. The CRSC statute does neither, and therefore, according to the government, the Barring Act gives us our statute of limitations. I will now turn things over to the audience for Q&A. We don't have any current questions in the chat, but we do have one that was just put in our private chat. So let's read this to the audience. Wisconsin versus Yoder included the clarification that the education requirement could be lifted because doing so would not create future wards of the state, i.e. that the Amish self-directed practices were sufficient to produce self-sufficient adults. And the question for Sarah is, in Mahmood, is there any corollary to be invoked here?
Hey, everyone. I think the element of compulsion is going to be very important here. Remember, this is a compulsory educational requirement, and the court engaged in a balancing test in which they determined that the violation of the criminal penalty for failing to send an individual to public education up through a certain point was too onerous a burden on the Amish way of life, because at a certain point, they are obviously an agrarian community. They need young people to help build farms and, transpire in what is believed under the Amish faith to be essential to their community way of life. I think that is something here that's going to be very critically important for the court, and whether or not this really does interfere with that fundamental right to direct a child's religious upbringing. And the religious upbringing element isn't just the education of a child, but it's also in an individual's way of life. I think the Supreme Court, based on its jurisprudence, is going to take a wider lens approach to the free exercise clause and make sure that when it engages in such a balancing test, that element of compulsory participation in LGBTQ-themed discussions, curriculum, storybooks, does not, in the end, outweigh the 14th and First Amendment rights of parents to direct their children's religious upbringing.
Thank you, Sarah. I have a follow-up question myself. As you mentioned, Sarah, usually when we see these kinds of claims, they do sound in parental rights. And this is, in fact, a fundamental right that's been recognized by the Supreme Court. Do you have any speculation as to why this case was framed in terms of a religious right alone?
I think a couple of different reasons, Ellen. That's a very astute question. First of all, this is the first time the Supreme Court's weighed in on any permutation of the parental right since 2000 in Troxel versus Granville. So we have yet to hear what the Supreme Court has to say about parental rights. It's been a quarter century of silence on this. I would say that the particular framing here makes this an easier analysis for the actual justices to wrestle with, because there is a direct implication on the nature, for example, of individual beliefs on humanity, or, for example, the immutability of sex and the creation of human beings as male and female. That is an essential element of many faith traditions. And so this multi-faith coalition of parents presenting that particular issue makes this, I think, an easier issue, an easier claim for the justices to wrestle with. It may have been why it was structured the way it was. I think also, based on what we've seen, is a queasiness to deal with some substantive due process analysis. Obviously, some of the justices have indicated, I give you Justice Thomas's concurrence in the Dobbs decision, often cited for the fact that we were going to lose all substantive due process iterations, from interracial marriage to contraception, when in fact that's not the case. What he said was these might more properly be rooted in the privileges and immunities cause. So I think here, because we can address it strictly from a First Amendment question without having to go to the stickier nature of longstanding, more than 100 years, but still problematic substantive due process, I think that's probably why it was structured the way it was.
Thanks, Sarah. Oh, for a world where we can understand the privileges or immunities clause as it was supposed to be understood. I hope you'll forgive me for asking this follow-up, but could you give a couple thoughts maybe on the future of parental rights as a fundamental right? Is the court going to take up whether they indeed exist in a substantive due process skeptical world, or are they going to move into the First Amendment or something else entirely?
That is a great question. I'm going to tell you right now that the court had before it 2 cases that it did not grant review on, one out of the 7th Circuit and another, not surprisingly, out of the 4th Circuit, who seems to be a bit less, I would say, supportive of parental rights in practice and public education. It also came out of the Montgomery County School Board District. But we saw 2 cases specifically related to what are known as these gender secrecy policies, in which public education, public schools have expressed policies in place that overtly hide gender identity information from the parents of minor school children if the child believes that those parents are going to be somehow unsupportive. I will say, simply as the mother of 3 children, my parents are often unsupportive of what my perspectives are and how they ought to be raised, but it is still my constitutional right to be able to raise them as I see fit until they are emancipated. But those questions are very likely to make an appearance, whether or not those types of policy, either on a facial or an as-applied basis, are violative of the 14th Amendment right to direct one child's upbringing by their parents. This is a significant question. In his dissent from denial of cert, Justice Alito actually said this is a growing issue of national significance. Well, we have reason to believe there may be one coming out of the 11th Circuit and one coming out of the 1st Circuit as well that will eventually make it to the Supreme Court, that will again go to this 14th Amendment question. Is it an unconstitutional interference with the fundamental right to raise a child as a parent wants if the school actively obfuscates and hides that minor's gender identity information from their parents? Very tricky question. The analysis is going to require questions of whether or not these are executive acts, whether they are more legislative in nature, whether or not these are facial or as applied challenges, and what in fact the 14th Amendment conceives of when it talks about this fundamental right right, rooted in 1923 in Meyer versus Nebraska. So my inclination, if I'm reading the tea leaves correctly, is the next iteration of parental rights to make an appearance at the Supreme Court is probably going to be on these gender secrecy policies. And there are approximately 1,200 school districts in the country that have these express policies in place.
Thank you, Sarah. I'm going to jump for a minute to the equally culture war issue of Article 3 standing and throw a question to Professor Fitzpatrick. You know, in your discussion of LabCorp, I really am reminded of TransUnion, which was a case where the Supreme Court granted cert on an extremely similar question, right? Whether Article 3 permits a damages class action where a majority of a class suffered no injury. And in that case, in TransUnion, the court ended up not deciding the question as well. And so what are your thoughts on whether the court is in fact going to answer the question this time or continue to sidestep it for another day?
Yeah, it's a great question, and you're right. The same question came up in TransUnion, and in TransUnion, the court decided that at the judgment stage, when you have a trial judgment and you have to distribute the money, at that point, you cannot include any class members who were not injured, that would violate Article 3. But they left open, as you noted, the question of what the rules should be at the class certification stage. I honestly think the question is so difficult to answer well that I think the court probably wants to avoid it if there's any reason to avoid it. And like I suggested in my remarks, I think there's a lot of reasons here. There are perhaps no uninjured class members here at all. In fact, there's reason to think every class member was injured by the way that the class was defined. The reason the question is so hard is because there is a formalist appeal to the notion that every class member has to show Article 3 injury. Otherwise, the court has assumed jurisdiction over people for whom it cannot adjudicate their claim because they have no standing. There's a formalist appeal to that. I'm not sure if it lines up that well with the history, as I intimated earlier, but there's at least a formalist appeal to that, and I can see the court attracted to that notion. The problem is, if you go down that path, it's really hard to see how class actions are going to work. You really are putting class actions on the chopping block because it's pretty much ubiquitous to have uninjured class members in a class, unless you define the class so narrowly that only people who have a good claim, frankly, which is how they kind of defined it here, are in the class, then you're going to have class members who don't have injuries. You know, if it's a consumer case about dishwashers, you want the class that says everyone who bought the dishwasher. You want the class to say everyone who bought the dishwasher because you want who is in or out of the class to be clear. You want to know what kind of res judicata am I getting from my class action? Even defendants want to know that, frankly. And so, you know, you don't want to have to define the class in terms of the merits. And that's where I think the Supreme Court would be leading us if it went down the LabCorp path. And that's unappealing. You know, I think from a policy perspective, a functionalist perspective, it's unappealing to be either throwing the class action out or saying you have to define the class in terms of the merits and thereby make it very unclear who is actually bound by a class settlement or a class judgment. And I think those competing tensions between the functionalist view of the merit of class actions versus the formalist view that, gosh, shouldn't everyone have this injury? I think it's going to make the court reluctant to answer the question unless they really, really have to. And as I said here, I'm not sure they really have to, so I don't think they will answer it again.
What do you think would be kind of the most helpful originalist piece of scholarship that could be useful to the court in a case like this, so that you know, maybe not now, but someday we can get a
Yes.
final resolution?
So it's a great question, and I think there's two strands of originalist scholarship that would be super helpful. So first is the strand that I alluded to earlier, which is just on actual injury doctrine to begin with. We have this question only because of this actual injury doctrine. And if that is originalist, if that is made up, maybe we ought to just solve that problem and thereby eliminate the need to answer this class action question. The other strand of scholarship that would be helpful is to go back and try to take a look at how courts treated class actions around the time of the founding. There were class actions around the time of the founding. They were based on a representative action that existed in England. Can we glean anything from the practice of how courts treated class actions back then? Now, there is a brief by legal historians that's on the class members' side in this case. They say courts took jurisdiction to decide common questions of the class and then left for a later day what to do about any individual standing, injury, damage type questions of particular class members later. The trouble is before 1966, most of our damages class actions were basically opt-in class actions. The opt-out change happened in 1966. And so I've been trying to sort out, how do we take this history where the court decided the common question and then address the individual questions later? How does that map onto an opt-out class action where class members don't have to opt in, where everyone's in unless they opt out? Can we really map that history onto the opt-out situation? Someone needs to do some work on that. What lessons can we learn from the history in a world where our class actions are opt-out instead of opt-in?
Thank you, Professor. For all of our students or young scholars in the audience, I think Professor Fitzpatrick is giving you some great topics. We have a question in the chat from Chris McCrae for Tim about Drummond. The Code of Canon Law states that a parent is obligated to instruct their child in matters of faith. The parents seem to have barriers to doing this themselves or through a local school. Is the virtual aspect of this school from the diocese a factor for Drummond?
I'm not quite sure I understand it. Like, the virtual aspect is just part of why the two dioceses wanted to create a charter, right? They already have local parish and parochial schools in the cities, but given the geography of Oklahoma, they want to be able to serve the whole state, including students in remote rural areas. So virtual is sort of the way to do it, right? There's not another way to get there. And since they're creating a new school and they qualify for a charter, they applied for one. Obviously, we want parents to be involved in the religious instruction of their children. And I guess that's sort of independent of school, right? Because, parents have for a long time provided religious education outside of classroom for their students.
Here's another question about Drummond. Drummond is a case that involves the interplay of the Free Exercise Clause and the Establishment Clause. Some scholars take the position that the Establishment Clause does not prohibit states from supporting religious establishments, but in fact protects their right to do so. Justice Thomas has supported this position. How, if at all, might a position like this be instructive in Drummond?
I think that position is exactly what's going on here. We know that it's inappropriate for the state, whether it's the state of Oklahoma, the federal government, any state, to discriminate in their programs on the basis of religion. And in fact, there is this sort of sense that excluding organizations solely on the basis of recognized religions is in a way a violation of the Establishment Clause. Right? I mean, what is the line of a religion? Is the school that does, Native American culture and tradition not a religious school? Well, they would say they're not, but Rene Girard would say that the culture is the religion, right? So if you have this sort of cultural distinctiveness, and that's okay to establish, but as soon as it's something we recognize as a religion based on sort of our history of what's been a religion in the United States, you can't get any public money. That would seem to implicate the Establishment Clause.
Thanks, Tim. We're running up very close on time here, and before we close, I'd like to ask Francesca and Professor Sisk, as we think about Zook and we think about Martin. What do you think are, in each case, maybe the most interesting amicus briefs filed? And Professor Sisk, I know you were involved, so feel free to talk about your own or about another brief.
Well, I certainly do think my amicus brief was an interesting one and raises an important issue that I hope the court will touch on. But turning to the other briefs, one of the most interesting ones, I think, is a bipartisan amicus brief by members of Congress, both in the House and the Senate, essentially saying, look here, we passed as Congress this law enforcement proviso insisting that when law enforcement mistakenly target someone's house for a traumatizing raid, that the government should be held responsible for that. How in the world is it that 50 years later, the government is held immune from that kind of liability? So I think that was an important voice to be added to the discussion.
Thank you, Professor. Francesca, anything to add?
Well, in the Zook case, there were 4 amicus briefs filed in support of the taxpayer. There were no amicus briefs filed in support of the government, which is often the case in tax cases in the Supreme Court. But for the most part, the amicus briefs that were filed in support of the taxpayer, the respondent in the case, echo this theme that the tax court is a much easier court to access for individuals and small businesses, and really emphasize the theme that it's very challenging if a case becomes moot in the tax court while it's underway. It's very challenging for the sort of ordinary person to restart the litigation in the district court. And so I think that does have some sort of real world appeal that really may affect the way the justices view the statute, which admittedly is not entirely clear about what exactly the tax court can address and what issues remain live in a case such as this one. So it'll be interesting to see how it all plays out.
Thanks very much. Thank you so much to all of our panelists for helping us think through the Supreme Court's April docket. Thank you to everyone who attended, and thank you to the Federalist Society for hosting this great discussion.
Well, thank you, Elle, and thank you to all our excellent panelists. This has been, as Elle said, just a great discussion, and we appreciate Elle's expertise in guiding the conversation. We look forward to having each of you back with us at a future program soon. For our audience, your feedback is always appreciated at info@fedsoc.org. And until next time, we are adjourned.